Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor.
Law firms will take this as a retainer.
What? It must be a law firm where they hungry as hell. Now you gonna help me with this parole I'm dealing with?
Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor. With one taste of our premium blends of all-natural ingredients, herbs, and spices, you'll fall in love with meat all over again. Judge Joe Brown's all-natural barbecue sauce collection is made up of 2 zesty flavors, original and spicy. There's only one way to bring order back to barbecuing. Just add Judge Joe Brown's all-natural barbecue sauce and seasoning, and you be the judge.
Let's go to the civil rights. People are losing their mind, and it's frustrating me because now they are creating these headlines. Trump is trying to roll back Civil Rights Act of 1965, and he wants to repeal Lyndon B. Johnson Civil Rights of 1965 Act. That's the headline. And where did this headline come from? This executive order. He issued an executive order on the 21st, ending illegal discrimination and restoring merit-based opportunity. Did you want to read this? So people took...
Read it. I'll read it. Section 1, purpose. Long-standing federal civil rights laws protect individual Americans from discrimination based on race, color, religion, sex, or national origin. These civil rights protections serve as a bedrock supporting equality of opportunity for all Americans. As president, I have a solemn duty to ensure that these laws are enforced for the benefit of all Americans. What's wrong with that? Now, yes, today, roughly 60 years after the passage of the Civil Rights Act of 1964, critical and influential institutions of American society, including the federal government, major corporations, financial institutions, the medical industry, large commercial airlines, law enforcement agencies, and institutions of higher education have adopted and actively used dangerous, demeaning, and immoral race and sex-based preferences under the guise of so-called diversity, equity, and inclusion, or diversity, equity, inclusion, and accessibility that can violate the civil rights laws of the nation. No problem with that. That's true. Illegal DEI and DEIA, those are the initials for the concepts. Those policies not only violate the text and spirit of our long-standing federal civil rights laws, they also undermine our national unity as they deny, discredit, and undermine the traditional values, American values of hard work, excellence, and individual achievement in favor of an unlawful, corrosive, and pernicious identity-based spoil system. Hardworking Americans who deserve a shot at the American dream should not be stigmatized, demeaned, or shut out of opportunities because of their race or sex. These illegal DEI and DEIA policies also threaten the safety of American men, women, and children across the nation by diminishing the importance of individual merit, aptitude, hard work, determination when selecting people for jobs and services in key sectors of American society, including all levels of government and the medical, aviation, and law enforcement communities. Yet, in case after tragic case, the American people have witnessed firsthand the disastrous consequences of illegal, pernicious discrimination that has prioritized how people were born instead of what they are capable of doing. Now, stop right there. Classic image that jumps to mind is that fat man-looking assistant chief of fire department, Los Angeles Fire Department, that got on there and said, she doesn't care if she can't pick up some woman's husband. He got himself in that problem in the first place. Now, that's just kind of stuck on stupid that comes up here. Now, Section 2 policy, it is the policy of the United States to protect the civil rights of all Americans and to promote individual initiative, excellence, and hard work. I therefore order all executive departments and agencies to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement of actions, consistent orders, and requirements. I further order all agencies to enforce our long-standing civil rights laws and to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. Well, he's in compliance with the most recent Supreme Court decision written by Chief Justice Roberts last year, which, by the way, complies with or closely follows what I participated in helping to draft in 1967 with one of the first affirmative action programs in the country. So I see no problem. Section 3, terminating illegal discrimination in the federal government. A, the following executive actions are hereby revoked. Small 1, RI, Executive Order 12898 of February 11th, 1994, federal actions to address environmental justice in minority populations and low-income populations. 2, Executive Order 13583 of August 18th, 2011, establishing a coordinated government-wide initiative to promote diversity and inclusion in the federal workforce. Small case, sub 3, Executive Order 13672 of July 21st, 2014, further amendments to Executive Order 11478, Equal Employment Opportunity in the Federal Government, and Executive Order 11246, Equal Employment Opportunity, and 4, the Presidential Memorandum of October 5th, 2016, promoting diversity and inclusion in the national security workforce. Sub B, the federal contracting process shall be streamlined to enhance speed and efficiency, reduce cost, and require federal contractors and subcontractors to comply with our civil rights laws accordingly. See, he's saying you have to comply with the federal rights laws. Sub 1, Executive Order 11246 of September 24th, 1965, Equal Employment Opportunity is hereby revoked. For 90 days from the date of this order, federal contractors may continue to comply with the regulatory scheme in effect on January 20th, 2025. All right.
Can you elaborate on that? What did he revoke? What is that?
Well, I worked for EEOC during this time period. So that particular thing had to do with some clarification of what had been mandated. That's under Title VII of the Civil Rights Act. That's not touched. This is just an executive order that deals with certain administrative things. However, I would note that this may be a red herring because during the Reagan administration, now, what I was saying is that I worked for EEOC, closely proximate to when this was going on. And what it's all about. Can you see me?
Yes.
Okay, I can't see you. Okay, all I see is the order. I work there closely proximate to this, and they're talking about some executive orders that I think are already actually undone. During the Reagan administration, when they appointed Clarence Thomas as a 20-something-year-old to run EEOC, he sort of put a hatchet job on everything that EEOC had been doing, and what has wound up happening is that Title VII has been cost prohibitive to basically anybody doing anything with it except one group protected, and that would be those who were female executives or well-to-do female employees who got mistreated, who had fallback with a spouse at home who could afford to finance action being taken under Title VII. Very few people can afford to prosecute a Title VII action now because you just lost your job, you're broke, you have no fallback, and you're just out of luck because there's too much red tape and too many lawyers don't want to take anything that's a cause. They want to make money, immediate money, so you don't have any, and it's a lot of work to pursue a claim, so none get pursued of any significance. So most of what is in that Johnson executive order was of offense to the Republican Party at the time, but I'm not so hot against it, but it is sometimes subject to abuse when they start talking about entitlement. And the entitlement is caught up with what happened with affirmative action. It slipped from something that prohibited discrimination based on race, color, national origin, religion, sex, and then it got modified. It isn't even in this one, with medical condition and then age.
One second. I need you to swing it back to this because
I am, because it's what this thing is he's setting aside is, that was the question. You see, what wound up happening is that it switched from protecting, meaning a shield, so no one is harmed because they are any of these things. It became something that was used to promote people who fit in this category above all other categories, which became reverse discrimination against non-inclusive categories. In other words, I can't discriminate against you because you are a woman. I have to protect you so you have an equal opportunity. That got turned into something where because you are a woman, I can discriminate against all other people to help you out, not protect you.
Okay.
In other words, I can give you a boost, not just a neutral playing field. That's what he's trying to deal with. And I don't think Johnson intended it for that purpose either, but it's one of these things that by its wording has been abused. So with that, I think let's move on to the next thing.
Right.
The federal contract, okay, the executive order, that's what we were talking about right there. Sub I, that one from 1965. By the way, for black folk, my answer on that one is, if you're in a position right now in 2025 to have to rely on that from 60 years ago, you're pretty pathetic. Get your shit together and take advantage of the opportunities that present yourself, because you don't need to conceive of yourself as a victim. Send your kids to the library, go to the library yourself, get it together, and stop trying to worry about whether they're going to legalize marijuana on the federal level. That's a suggestion. Okay. 2, the Office of Federal Contract Compliance Programs within the Department of Labor shall immediately cease A, promoting diversity. Go up. Holding federal contractors and act contracts. Wait. Okay. A, promoting diversity. B, holding federal contractors and subcontractors responsible for taking affirmative action. And as I said, there's a way around that. All you need to do is comply with what Justice Roberts wrote in his recent opinion, and you will have the strongest old-time affirmative action back in place. C, allowing or encouraging federal contractors and subcontractors to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin. I didn't even see that, but that's what I just got through saying. In other words, you can make it equal, but you can't give someone an advantage. Okay, keep going. In accordance with Executive Order 13279 on December 12, 2002, Equal Protection of the Laws for Faith-Based and Community Organizations, the employment, procurement, and contracting practices of federal contractors and subcontractors shall not consider race. Okay, keep going. Color, sex, sexual preference, religion, or national origin in ways that violate the nation's civil rights laws. Okay, that was this thing that was set up through Bakke, so we got what we predicted in 1972 would be reverse discrimination and would lead to this. The head of each agency shall include in every contract or grant award a term requiring the contractual counterparty or grant recipient to agree that its compliance in all respects with all applicable federal anti-discrimination laws is material to the government's payment decisions for purposes of Section 3729, et cetera, et cetera. Now, what does that mean? You can get affirmative action if you just get off of the asinine fixation on having to come out, we helping out black folk, we helping out Indians, we helping out this. Just be smart enough to frame what you're trying to do in a way that looks neutral, but has an affirmative impact on the people you're trying to help or put in an equal position.
Can I say something here?
Go ahead.
Because it says up here though, because now I am questioning this a little bit, and it says two, well, double I, that means two, right?
Yeah.
The Office of Federal Contract Compliance Programs within the Department of Labor shall immediately cease, and then it goes A, B, C. Okay.
Promoting diversity, holding federal contractors and subcontractors responsible for taking affirmative action, and
allowing or encouraging federal contractors and some subcontractors to engage in workforce balance based on race, sex, color. Okay, so they're saying balance meaning, oh, I have 5 men working, let me hire 2 women.
Yeah, sort of like that. Now, the problem with the whole thing is it is subject to existing case law, that is, decisions by the U.S. Supreme Court, and the president can't get around that, at least not since Marbury versus Madison, 1803. What is that? 2 years ago. So no, he might have a hard time getting around that. In other words, the Supreme Court can overrule the president's decisions if they find it lacking in constitutional authority. Now, the Supreme Court has said that race can be considered as a factor, but it cannot be the determinative factor. In other words, it can set the landscape. So presumably, if you have people who are hired on merit, you see, you're going to have to incorporate in this process, which I'd recommend to anybody involved, a competitive assessment of job history, job skill level, and or other factors that indicated a suitability for the position. That's the third one. And that's where you're going to have to hang your hat. In other words, let's say that this person grew up in a such and such area. He's done this, that, and the other. He has gotten this. He's gotten that. He's suffered this. He's suffered that. Well, you have someone over here who's had a wide open red carpet all through life. They might not be as impressive an employee. Also, you're going to have some problems right now because you've got Generation Z. The first of them are now in a position to start hiring people. And they're doing some weird things because they don't even like to hire each other. So we're going to get a driving engine out of the private sector that is not going to hook up very well with this because they have some other criteria they want to bring in, which is, interestingly enough, fixed on looking at somebody's application or resume based on what they like to do for recreation rather than what they have done in terms of employment as a criteria for hiring.
All right, let's just run through this because it's something as one comment that I want to say, but I'll say it once we run through this. So where did we leave off at?
Okay, we've done that one. The head of each agency shall include in every contract a grant award, a term requiring the contractual party or grant recipient to agree that its compliance in all respects with all applicable federal anti-discrimination laws is material to the government's payment decisions for purposes of this section, et cetera, et cetera. All right, next one. A term requiring such counterpart or recipient to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. C, the director of the Office of Management and Budget, OMB, with the assistance of the Attorney General as requested, shall review and revise as appropriate all government-wide processes, directives, and guidance. Now, you know what the weakness of all of this is? It's got to do with what do they mean by diversity, equity, and inclusion, etc. What do those terms mean? Since they are colloquial terms, they're not going to be in a Black's Law Dictionary. There is very little, if any, case law that has dealt with those terms in terms of the in respect to their definitions. So this whole setup is going to be vulnerable to a counter of it being void for vagueness.
Okay.
I don't know if they teach it in law school anymore, but this was a precept you taught to law students at a good law school in the first year. Understand the vulnerability to attack when something is void for vagueness. In other words, what the hell does that mean?
All right, so shall we proceed?
Go ahead. All right, next one. We run this. The exercise reference. Well, let's go back. I didn't read that one. Back now. A term requiring such counterpart or recipient to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. Okay, what does that mean? That could be something open to a little bit.
Oh, we read that
debate.
one and OMB as well.
Okay. Review and revise as appropriate all government-wide processes, directives, and guidance. 2, exercise references, excise references to DEI and DEIA principles under whatever name they may appear from federal acquisition, contracting, grants, and financial assistance procedures to streamline those procedures, improve speed and efficiency, lower cost, and comply with civil rights, scroll up, laws, and terminate all diversity, equity, and equitable decision-making, equitable deployment of financial and technical assistance, advancing equity and like mandates, requirements, programs, or activities as appropriate. Now, Interestingly, there is going to be something that this does not anticipate, and you know what that is?
What?
10 to 15 years, nobody in this country is going to be part of a majority. Everybody will be a minority. So just what the hell are you doing? Do you realize what this really winds up doing? So the people that object to this are going to find themselves, if they prepare to be on equal footing, and the people who are trying to keep from being subjected to reverse discrimination are going to find themselves subject to direct discrimination. And let us say that you get a situation we are so familiar with, like in Georgia, Fulton County, Cobb County, DeKalb County in Atlanta. We have a situation where, say, black folk run stuff because they run the government. They have the hiring and firing say-sos, and somebody's saying, hey, what happened to the white people that used to work here? There aren't any. They seem to not get jobs. And somebody said, oh, well, we were just being neutral as per that 2025 executive order. So it can go both ways.
All right, let's finish reading.
Fascinating. Now, next one, encouraging the private sector to end illegal DEI discrimination and preferences. Again, you can't have any kind of discrimination or preference. The heads of all agencies, with the assistance of the Attorney General, shall take all appropriate action with respect to the operations of their agencies to advance in the private sector the policy of individual initiative, excellence, and hard work identified in Section 2 of this order. Now, what the hell are you going to do with all of these privileged asses who are entitled and sheltered and think they should have everything handed to them? Interesting. Let's see what goes from there. Okay. All right, next one. I don't think we need to read this whole thing. We get the gist of this. It's just repetitive and applying it to various circumstances. Other actions. Within 120 days of this order, the Attorney General and the Secretary of Education shall jointly issue guidance to all state and local educational agencies that receive federal funds, as well as institutions of higher education that receive federal grants or participate in the federal student loan assistance program under Title IV of the Higher Education Act, 20 United States Codes annotated Section 1070 et seq, regarding the measures and practices required to comply with Students for Fair Admissions, Inc. versus President and Fellows of Harvard College, 600 United States Reporter at page 181, decided in 2023. Interesting case. So, and they're acknowledging that they do have to comply with Supreme Court decisions. That's good. But those decisions still need to be expanded upon. It might get interesting. All right. Anything else?
You want to skip to Section 7, scope
Well, let's
disorder?
see. This order does not apply to lawful federal or private sector employment and contracting preferences for veterans of the U.S. Armed Forces or persons protected by the Randolph-Shepard Act, Section 20, Title 20, United States Codes annotated Section 107 exceed. This order does not prevent state or local government, federal contractors, or federally funded state and local educational agencies or institutions of higher education from engaging, scroll up please, in First Amendment protected speech. In other words, you can oppose it and say we don't like it with no penalty. That's First Amendment speech. This order does not prohibit persons teaching at a federally funded institution of higher education as part of a larger course of academic instruction from advocating for, endorsing, or promoting the unlawful employment or contracting policies prohibited by this order.
Practices.
It does not prohibit them from advocating. Scroll down again. Scroll up a little bit. No, scroll down. This, you got to bring it up. Move it up. Okay, stop right there. Stop. Okay. I wish I could just drop it down. Yeah, there you go. Freeze. This order does not prohibit persons teaching in a federally funded institution of higher education, etc., from advocating for, endorsing, or promoting the unlawful employment or contracting practices prohibited by this order. In other words, you can speak against this order without First Amendment consequences. It's your right to say you don't like it. That's good.
General provisions.
Nothing in this order shall be construed to impair or otherwise affect. That's this frou. Keep going. Keep going. That's this administrative. This order is not intended to and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States. In other words, it preserves sovereign immunity. That's all. That's just so somebody doesn't say you authorized us to sue the government or these people. So
okay, so with all that was a lot. But see, this is why I wanted to have this as a separate show for you to break it down. So with this headline, people are going around saying such as Donald Trump has revoked the Equal Employment Opportunity Act of 1965.
No, he didn't. All he did was just strip away the fruit that's been added to it that creates what we said in 1972 at UCLA Law School, at Berkeley Law School, at Bolt Hall Law School, that's up there, at Stanford Law School, at Harvard, Yale, Princeton. We said that if you change stuff, you're going to run into reverse discrimination. We were right, and it did, and it led to this. So all it's doing is stripping that away. Nobody is going to suffer anything. You pragmatically.
So, but here's my question going back to the federal contracts, because federally, under federal law, contract or redevelopment companies or construction companies, you have to hire 10% up to I think up to 10%, or a minimum of 5%, or 10% of your employees have to be people of color, because and this was under those 1965, 64 and so forth acts, because prior to that they were not hiring particularly Black men, because these were men that were in those type of fields, but they were not hiring Black people. They were literally not hiring Black people. They were hiring white, sometimes maybe other. So that's why it became federally mandated that if you have a federal contract, whether it's fixing the roads or whatever the case may be, you have to have 10 or 50, up to between 10 and 15% of your employees have to be people of color,
okay.
Minorities.
Let me give a brief explanation. At the time this was passed, this is 1965. 1973, when I set foot in Memphis and Shelby County Juvenile Court, it had just been integrated so Black lawyers and Black litigants could come inside the courtroom and sit with everybody else. See, that's not what the situation is. There's a Black judge that's over that court now, and a lot of Black employees. Things have changed. What this early executive order was addressing is no longer the situation in the United States of America. If you go back 50 years before that, you're in 1915 when Jim Crow and segregation were absolute and ironclad. So things have changed drastically. So there's no point in whining about, oh, woe is me, because nothing you deal with is going to be like it was then. Nothing.
But see, these laws, I agree with you, but these laws were passed, these public policies were passed so that Black people would not be discriminated against. So it wasn't like, oh, I need help, I need a handout. These companies were literally discriminating against Black people,
Yeah.
right? So now, but now we have a whole bunch of other people, minorities, people. This is what I'm saying now. This is what I'm saying is the fact that it's not about giving preferential treatment over someone because they're Black or because they're a woman or because they're gay or what have you. It was a time that companies were not hiring them, right?
Yeah, but that's not the way it is right now, except in certain
maybe, and this is my pushback. It's not like that now today. But that's because they know if they were to try to use those practices, they could be sued. It's against the law.
But they don't have to worry about being sued because they've added so much red tape to the process of pursuing Title VII remedies that the only people that are in a position to do anything about it is the female offended bunch who have husbands and financial circumstances and sponsors that allow them to pursue sexual discrimination. It's being used to pervert the whole damn thing for sexual orientation purposes, which was never thought about, never included in the scheme. And it's what it is. Now, you see, where it comes into play is 1965. By 1970, 71, the U.S. Supreme Court has held that what you ought to see if there's no discrimination is that the percentage of any group within an employment population ought to reflect their percentage in the general population. In other words, if it is something like you've got police officers and 14.9% of the urban population that these people police is, say, Hispanic, then you would expect 14.9, 15%, 14% of the police hired to be Hispanic, because basically that's a job that does not require specialty in higher education. All right. So that's what they decided with the Supreme Court after this. So that executive order was essentially obsolete. And what they were trying to do is turn it around to deal with gender bullshit.
Right. So basically, this particular executive order, what you just went over, that's just Trump getting rid of that DEI shit.
Yeah, that's all it is. And nobody's
not discriminating against anyone, or it's not. He's just saying you're not going to get hired because you're Black or because you're gay or whatever. You're going to get hired because you are qualified.
And notice 3 or 4 times in there, he specifically reiterates this is to ensure compliance with existing civil rights laws.
Yes. Let me just add one more thing because we actually went over, but let me ask one more thing. This prior administration, Biden administration, they ushered in this DEI. You didn't need DEI to be ushered in because we already had laws on the books. So if you're saying that Black people or minorities or gay people or handicapped people, whatever, were being discriminated against, then where are the lawsuits? You can't sit up here and say you're doing something right. Well, you first need to tell me what was the wrong. The wrong would have to be companies intentionally not hiring quote unquote minorities, but they were not doing that. What it was, these companies that accepted these DEI programs and agenda and policies, that was a $750 million budget annually. that this administration laid out under DEI. 750 million, almost $1 billion. So companies will say, oh yeah, we will force our employees to go to these DEI training courses because you're giving me federal money, millions of federal dollars. So as a corporation, yeah, I'm going to usher in those policies because there's money attached to it. Those companies were not discriminated against Black women or gay people because they were already hiring them. Wait, let me just say this. They were already hiring them. So, all right. So my question is, were these companies not hiring these people? Because that would be a lawsuit.
Well, yeah, but I'm saying it's too expensive now since Clarence Thomas was director of EEOC to pursue a Title VII case. Nobody can afford it except certain women, and they tended to have these executive level positions where they're getting 180, 250,000 a year, so they're not just broke. Okay, and what we are really talking about is something else. You have to read between the lines. What is being done with DEI now has very little to do with hiring Black people. It has very little to do with hiring Hispanics, very little to do to hiring Native Americans or hiring Asians. What it has to do with, and it's being politely inferred here, is do you support the rainbow cult? Do you support this new faith that we're trying to spread? That's where the problem comes in. And I'll tell you where the biggest offender in the United States is right now, where they really do it the old time way, is Hollywood in the entertainment industry. If you don't push that garbage they're trying to push on the American public about normalizing this strange sexuality, then you get really jacked around unless you make them too much money to ignore. So when you get that, then you get a propaganda campaign that makes people acclimated to this kind of thing and assume it's acceptable. Do what you want to do in your bedroom. That's your own damn business. But when it comes to public advocacy and forceful imposition of something by government action, then that's another thing. So I'll digress very slightly, but you're finding out how all of these entertainment celebrities were really getting their freak on now that certain stuff is coming out. That was a requirement for Hollywood. It didn't make any difference what you were. Are you a freak? If you're a freak, you get affirmative action. If you are not a freak, you get reverse discrimination. And that's the Hollywood industry, the publication industry that makes the propaganda that establishes the mindset of the American public. It's crazy. So I think that may be what he's getting with. In other words, she's doing something without saying it. Again, an example of you can get away with, you can accomplish a lot if you don't have to sit there and broadcast what you're doing.
And with that, I want to say thank you to everybody for tuning in. This has been another episode of Injustice for All with Judge Joe Brown, Part 2.
I have one last statement, very brief. We might not have to worry about these injustices if we paid more attention to personal and professional and vocational performance rather than worrying about whether they're going to legalize reefer so you can get high.